All right, good morning, everyone. Thank you for joining us. I am Lisa Smalls, the Interim Director of Organization and Community Initiatives, and we welcome you to this month's professional development presentation about AI, copyright, and the arts. Joining us this morning are Ashley Keaton and Meredith Reagans. After this presentation, you will receive the recording as well as the slides and any follow-up information that the presenters would like to offer. And just briefly, housekeeping. South Arts receives support from the National Endowment for the Arts through a partnership agreement to produce workshops such as these and conduct additional programs for our constituents across the region. Please visit our website as well as the NEA's website for additional information and opportunities. Also, we have our Q&A pod open. So please, you can put comments in the chat, but if you'd like to ask questions, please put them in the Q&A pod. And at the end of both presentations, I will read them, and then you'll be able to drop additional questions if you have so as time permits. And without further ado, I turn it over to Ashley.
Hey, everyone. It's great to be here. Thank you to South Arts for having me, and thank all of you for attending today. I hope that I can impart some information that's helpful to most, if not all of you. And before I begin, I should say, first of all, I'm glad that Lisa clarified that she will be asking the questions that you all have that you're submitting in your chat, because it's very difficult. I don't know why. I've Zoomed like every day since the pandemic almost, and I still have a hard time toggling between the chat box and presenting. So that's good. So I will get to your questions, but it's difficult for me to do that while I'm presenting. So I just don't want you to think I'm ignoring you. So with that said, what I'm going to do is I'm going to go over a very basic, like the fundamentals of copyright. And I'm going to pull up my presentation here, but some of this will apply to most of you. Some of it won't, because because I'm going to address issues that for instance, some visual artists have that musicians might not have, and vice versa. And so I hope that when I'm going through this presentation, that it has enough clarity for you to understand that. And if not, again, please ask questions, because I want to make sure that I provide all the information that you all need. Thank you. Okay, let's make sure you all can see that. Okay, get this ribbon out of the way. Okay, and everyone can see? Yay, thumbs up. All right, great. And you'll have to, forgive me for my graphics, because I get a little too excited about them. So my students, it drives them nuts. So again, so today we're going to go over the fundamentals. We're going to go over the definition of what copyrightability is, when it actually subsists, when we're actually talking about something that is subject to copyright protection, as opposed to an idea or a concept. Then we'll talk about the application of copyrightability. We're going to talk about what we're going to break down the definition of when copyright subsists. We're going to discuss the nature of authorship and ownership, and copyright assignment and transfer. And then we're going to get into protection and enforcement. So we'll talk a little bit about registration and infringement, and we'll end with an introduction to some basic fair use cases, as fair use is a defense to infringement. And then I will hand the baton to Meredith from there. Oops. Okay, doesn't need to. Okay, so I like to break down the definition of copyrightability, like when copyright subsists, into three parts. Okay, that's not how it's broken down in the Copyright Act, but that's how I like to break it down, because for copyright to subsist, you have to have an expression of a work of authorship that is original. Okay, so what an expression means is something that can be perceived, reproduced, or otherwise communicated. Basically, if you can copy it, right? If it's reproducible. And an expression is very distinctive from an idea. An idea is something that is more conceptual, whereas an expression is tangible. That's exactly what it is. That's a distinction. And that's when if you have an expression of a work of authorship, and the work of authorships are defined by the Copyright Act, they were legislated, that are original, and we'll get into what it means to be original, then copyright subsists. Okay, so that is when copyright subsists. That's not the definition of copyright. Why is this doing this to me? Copyright itself is actually a bundle of rights. It's not one right, it's a bunch of rights. It's 5 or 6 rights, depending on the work of art. So copyright confers upon the author or the claimant the exclusive right, the only right, unless they, convey otherwise. The only right to reproduce their work, to prepare derivative works, to distribute their work, to publicly perform their work, and to exhibit, to display their work. The duration of copyright is life of the author plus 70 years. Okay, so it's the life of the last living author plus 70 years. If it's a legal entity, it's 95 years from publication or 120 years from creation. But for most of you, you're going to be individuals, so it's the life of the author plus 70 years. Public domain, anything that was, the general rule, this is a little nuanced, but like there are copyright professors that, get paid to debate about this, but the general rule is that anything published before 1928 is in the public domain. So anything after that is subject to copyright protection if it's copyrightable. The copyright notice is the C with the little circle around it. It's right here. That used to be a lot more important than it is today. It used to, the way the law was written and interpreted was that you needed to have a copyright symbol and notice on your works in order to maximize your opportunities to protect your work. And anymore, it's just best practices. And that's why I bring it up, because a lot of people don't put that on their works. And sometimes it's kind of tacky to do it because you don't want a big copyright symbol on your painting. And, especially for jewelry artists, they don't want the copyright symbol on their jewelry, rightfully so. But to the extent that you can provide it, notice to the public on your works without compromising the creative nature and the aesthetic appeal of your works, then I highly recommend putting that copyright notice, just because, it's kind of like, I tell my clients, people are going to steal your work if they want to steal it, but anything you can do to deter them from doing it is best practices, and it's also common sense. It's kind of like, I live in New Orleans, and I live in a very I live in a neighborhood that's quite lovely, but that has a storied history when it comes to crime. And so, I lock my doors at night. So it's just copyright symbol, putting the symbol on your work is just kind of the same thing. Just lock your doors, right? Like, it's not going to prevent anyone from stealing from you, but it might help. Okay, so we're going to revisit the copyrightability, and we're going to start going through and breaking down what that means. The expression of a work of authorship that is original. Sorry, whatever reason, I'm going to have to get out of presentation mode. I don't like this. Okay, this should be better. So the works of authorship, that's one of the 3 elements, as I like to say, the 3 elements of copyrightability. Works of authorship, what means a work of authorship is easy, right? Because it's legislated, it's written into the Copyright Act. So there's not a lot of room for interpretation. The works of authorship that are subject to protection are literary works, musical works. So when the Copyright Act makes reference to musical works, it's talking about the underlying work, the compositions. So think about the sheet music, dramatic works, pantomiming and choreographic works, pictorial, graphic, and sculptural works for all of you visual artists, motion pictures and audiovisual works, and sound recordings. And sound recordings, often, to have a recording, you have to have a composition, right? So sound recordings are going to embody musical compositions, but are very distinctive from musical compositions when it comes to copyright and music. And we'll get into that in just a little bit. We'll get into that a little bit more. And then architectural works. It doesn't apply to buildings, but it does apply to the blueprints. So that's the definition of works of authorship. So this is, again, legislated. And what you should know is that the scope of protection of copyright, and we're not going to get into all the nuance, but the scope of copyright protection extends differently to these works of art. And it's kind of confusing, and it's okay. Like, it's okay that you might be confused by that because it doesn't make a lot of sense. Basically, the Copyright Act, was the last time it was substantially revised was in 1976, before I was born and when people were still wearing bell bottoms. And so, when you think about that and its application to the contemporary context, to the modern day, it's a little confounding because you go, well, how is it that this act that hasn't really been revised all that much since, in the last, half century, apply to works that are being distributed and reproduced on the internet in the global marketplace? And one of the reasons why I would suggest we have copyright has become a more increasingly debated topic of conversation, at least in my sector, is because, we have this platform now. Everyone has this platform. Everyone has one of these, right? A phone. And we can all browse content all day long, right? And so, there's more opportunities to create content, to publish content, and to steal content than ever. And I don't think that the Copyright Act in its current form was really, written to extend that kind of widespread opportunity to consume content and to have that available on a, not just on a daily basis, but, at the tip of your, or at the click of a button on your phone, right? So that's why, when we go through this, I'll answer questions that apply in the contemporary context, because a lot of these cases that we go through and a lot of the language of the act was, it's kind of written in the Stone Ages, right? So I'm not suggesting that the act hasn't been updated, because it has, but not, not fundamentally. We had a provision that, I joke about Steve Jobs lobbying for when the record industry was plummeting to its death, the Digital Millennium Copyright Act, which safeguards multinational corporations from infringement, but not people like me and you. And then we've had a Music Modernization Act implemented since 76 as well. So there have been some advances, but for the most part, it's still as it was in 76 and before that even. So these are the works of authorship, and that should be self-explanatory. But the reason why I went through all of that mumbo jumbo was to sort of elaborate on why it is that all of these works have different scope of protection. So for instance, musical compositions have much greater protection than sound recordings. And a lot of that has to do with time, a lot of that has to do with lack of updating, and a lot of that has to do with lobbying. So, go figure, right? As those variables impact almost all forms of legislation. So we'll get into authorship. This slide is an image of one of our board president, Ella Project board president, and the president of the Mardi Gras Indian Council and chief of the Creole Wild West Mardi Gras Indian tribe, which I don't expect you all to understand what that means, but it's an indigenous urban cultural community here. And he is sewing three-dimensional patches here. So this is an image of him actually going through the creative process. So this patch right here would not be subject to copyright protection, but the final product, that's a three-dimensional sculpture to the right, would be, that's subject to protection. So what are expressions? We'll transition from authorship to expressions, and then we'll get into originality. So these are, just your basic, oil on canvas, choreography. If you're a choreographer, I was a choreographer, I was a dancer, and actually up until the pandemic, taught ballet and tap, and was a choreographer for a local studio. And for all of you choreographers or stage directors, et cetera, it's important to either film your choreography or to transcribe it, to write it down, in order for it to be subject to protection, because that's what makes it fixed in a tangible medium of expression. The screenplay and the motion pictures, The Big Lebowski is one of my favorite films. You can tell I'm older, but that's subject to protection. One is a literary work and one as a audiovisual work. This is musical composition, sheet music, sound recordings. This is my attempt at trying to locate an image of MP3 of metadata, and it didn't really turn out that great. This is three-dimensional works of authorship, pictorial, graphic, and sculptural works. Excuse me. I have a bug in my throat. And so those are the examples of the works of authorship set forth in the Act that are subject to protection as expressions. And again, ideas, that's why it's important that that the expressions be tangible, be reproducible, because ideas, procedures, processes, something that would be subject to patent protection, but not copyright protection, are not protected by the Copyright Act. So like a website is not protected by the Copyright Act. However, images, and certain images would be as works of visual art, and some of the text might be, if it's original enough, as literary works in a website. So the thing of it is while ideas are not protected by the Copyright Act, for those of you who might be filmmakers, or for all of you, the idea you have to have an idea before you create artwork. Sometimes there's not a very long process between concept and completion, and sometimes there is. And the reason why I pointed out filmmakers is because, there tends to be a pretty long amount of time between, the concept to develop a screenplay into the final publication or release of a film, even a documentary film. We're not talking necessarily about a major budget film. And we're, in the filmmaking process, whether it's, a small documentary crew or a large ensemble of, of producers and roadies and, what have you, all of the people that you see on the credits, that are streaming very quickly at the end of a film, that takes a lot of time and quite a lengthy process. And so I bring that up because until you have your screenplay, and that's protected as a literary work, or your film, which is an audiovisual work, then you're not all of the ideas and all of the work that goes into actually producing that final product. So you've got pre-production, production, post-production, is not protected by the Copyright Act. So it's important to know that your ideas can be subject to protection, and they exist along a broad spectrum, from like the actual seed, the germinating of, oh, I have an idea, to turn, as in this case, this Elizabeth Taylor Taming of the Shrew case, as I call it, where the producer here had an idea to adapt a Shakespearean play, which was in the public domain, into a film, and to add certain scenes, and to use certain director, and to do a frame within a frame, etc. There's a lot of thought that went into the production of this final product. And in this case, he contracted with the Burtons, with Elizabeth Taylor and her husband, to produce this film, and they reneged on it. And his claim that he had was viable. And the court agreed with him that they were in breach of contract, because ideas can be subject to contractual protection, not copyright protection, but contractual protection. So that's when you use things like confidentiality agreements. And they're not popular, but NDAs, as it relates to your products, and not personal relationships, etc. So there are ways to protect your ideas before they are subject to copyright protection. And I can talk to you more about that outside of this if you are interested. So we're transitioning now away from works of authorship and expressions into what it means to be original. Okay, what is the originality standard? And it's basically just a minimal amount of creativity. You don't have to have that much creativity. In order for copyright to subsist in a work of author, in an expression of a work of authorship, the originality doctrine requires there to be a minimal amount of creativity. And this was a case that I'm not going to get into because it was wrongly decided. But and this was one of the seminal cases that discusses the originality doctrine and whether or not this painting of the still of Dorothy is actually original. And there's been all kinds of debate about this case. I don't think that these are exact copies of each other, because we know that Dorothy's in Kansas there, and she's not, and she's on the presumably yellow brick road in this black and white depiction of her. And I've never seen legs or feet look like that. And she's holding Toto there, and it's not the same, right? This is why you don't necessarily want to go to court, even when you're right, because the judge here said, "Oh, that's the same," right? And that's been overturned, basically, in layman's terms since. But it's kind of funny because, and I tell my students in my class all the time, this is, you cannot remove the human condition from a court of law. And this is proof positive of that, because I don't think you have to be an artist to realize that this, this image of Dorothy, of the still of Dorothy, is just not a copy, right? And it would not be considered today. And the reason why I bring that up is because what the judge said is there wasn't a minimal amount of creativity, that it was just a copy, and it would be held it would be considered minimally creative today. Now, whether it was authorized is another question, but it's certainly minimally creative. So let's get into and that should sum up the originality doctrine. It's just super simple. You just need a minimal amount of creativity, right? And at that point, you have a work of author, an expression of a work of authorship that is original. So derivative works are works based on other works, right? Whether a derivative work incorporates a work in the public domain or work with existing protection. What you need to know is that if you're creating a derivative work, for all of you collage artists, et cetera, or people who are sampling music, if you're using any work, incorporating any work that has existing copyright protection, then you just need to clear it. You need to get permission, and that's all you need to know. And these are just examples of derivative works. Sampling, a lot of people don't think of sampling as derivative works, but they are. And this is a example of the post office using a painting of a sculpture as a derivative work. That's like a layered derivative work. And if you have questions about derivative works, just let me know, and I will be happy to answer. So, author versus claimant. You all probably know this already, but an author is the claimant unless and until the author transfers their ownership or of any given work, right? So, it's much like a house. Like, my house is 200 years old. The chain of title for my house is crazy. There have been more than 200 owners. There's a lot of yellow fever going on, but copyright, the chain of title is very similar. When you think about the fact that Michael Jackson owned a lot of the Beatles music, that's right there, shows you, it demonstrates how the ownership and authorship can be distinctive, right? So for the most part, with exception, and I love George Harrison and oh God, where's my brain? I love all the Beatles, but for the most part, John Lennon and Paul McCartney comprise most of the musical compositions, what you think about as the sheet music, the underlying work on behalf of the Beatles. Ringo Starr, sorry, I just have no idea why that happened. But the Beatles, the band, actually recorded most of those compositions. So that's the distinction in authorship for the musical composition versus the sound recordings, right? And the claimant to most of the Beatles catalog ended up being ABKCO, and that's actually what broke the Beatles up. It wasn't Yoko, it was their transfer of their catalog, which is too complicated to get into now, but that's a distinction between the author and the claimant. So the claimant is the person or entity that owns the actual copyright. And like I said, the author is the claimant unless and until the author transfers their ownership to another entity or to another person. If there are two or more authors and you meet certain requirements, then a work is a joint work. So a co-authorship and joint work has to satisfy a legal test. So to be a joint work, where there are two or more authors. You have to have a copyrightable work, so an expression of a work of authorship that's original. You have to have two or more authors, and they have to intend for their contributions to be combined, right? They have to have that intention. And that's the test for whether there is a joint work, co-authorship in a joint work, for those of you who are collaborating. So I said that authorship and that all authors are claimants unless they transfer their works. There is an exception to that, and that's the work for hire doctrine. So for people who are employed by employers who are commissioning works of authorship, like I'm a professor at Tulane, and if I was commissioned by them to publish an article and it was through the university, then Tulane would own that literary work. When I worked at Disney a gajillion years ago in international affairs and worked on some of the policies and practices for dealing with we actually had a World Cup issue. So we would do things like that. I mean, this was like in the 90s. Okay. And traffic control, et cetera. So it was a very exciting job, right? So when I was preparing documentation around these policies and practices, the Disney company would own that manual, that very riveting manual that everyone wants to read, right? But I was a dancer, and I kind of moonlighted for one of the original Lion King productions in the Animal Kingdom. And I'm not going to do anything about this, but I was not employed to do that. Okay. So they should have gotten a work for hire from me so that I, didn't have any claim on any of the rights in that choreography. But that is the difference between creating and contributing to works in the scope of your employment versus, being contracted. So whereas I was employed by the Disney company to work in international affairs, I was not as the gazelle and the Lion King, right? So all of the work that I performed in the context of my employment would have been owned by the Walt Disney Company. They would be the author and the claimant because I created that work in that context, and anything that fell outside the scope of my employment would not be. So it's important for you all to know that. So especially for, your session artists, if you are not presented with a work for hire in the studio, then you are a co-author of the sound recordings that you're on. And the sort of flip side of that is that, for those of you who are contracting with, who want to make sure that you own all of the rights to your sound recordings, you need to make sure that all of your session artists sign a work for hire agreement so that, you can maintain control of the work and can license it and can do with it what you want and administer those rights. Otherwise, you have a ton of people with claims in that bundle of rights, that copyright. So this is actually a big deal for people who are filmmakers, because as I mentioned earlier, there are a lot of parties to a film. And so, a lot of clients that I work with are very reluctant to issue work for hire agreements to their camera crew and editors and, other types of producers and actors, et cetera. And then, at the end of at filming, when no one's getting along anymore and everyone has rights, then no one can agree on what to do with it, right? And so then you have to shelve it, right? Because you can't warrant to Amazon or Netflix that that you have the right to transact around it, because there's so many people involved, right? You want to make sure, to the extent that you can, to the extent possible, that that any work of art that's being created, whether it's a public artwork commission, whether it's music, whether it's a recording, whether it's a film, what have you, that the arrangement around the rights is clear, understood, and to the extent possible, documented. It's really important, because I can't tell you the amount of times that I've borne witness to a project or, single work of music or what have you, that, where there's a party interested in using it and there's no way to actually transact around it because there's too many people who are not getting along, who don't agree on what to do with it. And that's a really sad situation. And I've had 2 film projects that refused to listen to me and refused to get their documents in order and were unable to actually exploit the films that were actually quite good, because nobody wanted to work with them because it was too risky. The exposure was too great, and the potential for liability was too much when you're working, when you want to exploit content that is not clearly arranged insofar as the rights administration. So that's important for you all to know. I'm not saying that you need to work for hire for everything, but I'm saying it is an instrument that can be used. And it's a relatively easy instrument to use. And that's a sample agreement for you all. You can just copy and paste this into a Word document, and there you have it. And so we're going to transition now from ownership and transfer. Going to go into the Music Modernization Act. But we're first going to talk about the performance right for all of you musicians in the room, in the virtual room. So as I said earlier, music has 2 copyrights. Well, we call it 2 sides in the industry. So the musical composition and the sound recording. So when Whitney Houston recorded Dolly Parton's version, or not version, when Whitney Houston recorded Dolly Parton's musical composition, I Will Always Love You, Whitney owned the sound recording, but Dolly's people continue to own the composition. And every single time Whitney's version or recording of I Will Always Love You is transacted, whoever is clearing those rights has to go first to Dolly or to Dolly's people to clear the musical composition, right? And that's how that works when it comes to music. So if for those of you who have recordings, if you've done covers, then if you want to transact around that, let's just say a TV studio or film studio wants to use one of your works, one of your recordings in a film, then what you need to know is that you cannot warrant, if you did not write the music, you can't warrant that you have the rights to the composition. You can only license the sound recording. And hopefully the folks that are licensing from you know that as well, and know to get the musical composition. But that would be that process, because they're very distinctive works. For those of you who are songwriters and recording artists, then you should know, for you songwriters, you should register with the performance rights organizations. And that's BMI, ASCAP, and SESAC. And what they do is they collect broadcast royalties that are per the public performance component of, or the right that's embodied within that bundle of rights that is copyright. So the right to perform, to publicly perform, is one of those rights within that bundle. And so when you hear something on the radio or a song that's being used on, in a television commercial, that sort of thing, even elevator music, jukebox music, these are public performances. Anytime you go to a live venue, and anytime you go to a concert, when you're listening to music on an airplane, on the overhead speaker, that's all public performances. And all of those venues or sources rather have to have blanket licenses with the performance rights organizations. And that's established by legislation as well. And so for you songwriters, the performance right is much broader in scope than an application than it is for then it extends to sound recordings. So basically what that means is that composers and songwriters can collect from more sources than recording artists right now, which is a flaw in the act, but it is what it is. And I hope that will change over time. But what you need to know, without me getting into too much detail, because this is like a separate class in and of itself, is that you need to be registered at the appropriate or applicable performance rights organizations. So for songwriters, that's BMI, ASCAP, or SESAC, and for recording artists, that's Sound Exchange. Now, the Music Modernization Act, what could possibly go wrong with it, right? It was proposed by Senator Orrin Hatch. It was endorsed by Kid Rock and signed by Donald Trump. I have no idea what could possibly go wrong with it. But it's, sorry, I joke about it because, Kid Rock is to be taken so seriously. But the Music Modernization Act, I shouldn't joke too much because it's supposed to be good, and it's an update to the Copyright Act, and I hope it works out. But what it intends to do is really good. What it intends to do is to extend protection to music, to extend the scope of protection to music, and it intends to require some of the streaming platforms to actually pay the mechanical royalty rates and to pay the licenses that they're already supposed to pay. But this gives this legislation, what it does is it basically, in my opinion, it gave a pass to Spotify and a lot of other streaming platforms who weren't paying songwriters. And so instead of, going after them for failing to do what they were supposed to do by operation of law, what this did is it created a quasi-governmental agency and a board that oversees the collection and distribution of mechanical royalties that are due to songwriters. So that's why I said I it's fine, it's good that Spotify's paying songwriters, but they were supposed to anyway. So now all of us, all of our tax dollars go to this agency that collects what Spotify should have been paying anyway. So that's if there's a little, sarcasm in my voice, that's why. That said, one of the things that the act did, that one of the major changes in the act that was really good, is that it revamps the court process for challenging royalty rates, which I'm not going to get into today, but that's a good thing. And it also extends rights to producers. So, and I'm not going to get into that in great detail, but it does do that, and so that's a good thing. Otherwise, I really don't. Time will tell whether this agency that oversees the collection of these royalties, whether that's really working out, because I think as of a few months ago, it was still in beta mode, but we'll see. And we hope that it works out. We do, because we're paying for it, and that's a good thing. At least we're paying for something that is supposed to work. So that's good. Now, I want to get into, I'm almost done. I want to get into copyright protection and enforcement. And you may ask, why is this going to be the fast part? Why is this why is this not going to take near as long as the definition of copyrightability? And that's because, it's very simple. Okay. So copyright subsists from the moment that you have an expression of a work of authorship that is original. You do not have to register your copyright with the United States Library of Congress in order to have protection. You are protected from the time you complete your work of art, okay? And that is important to know. And I was the most vocal proponent of copyright registration for years. And I, as an attorney, have to tell you that you should register your copyrights. However, as an advocate and as a person who is a real person, I will say that the Copyright Office, during right before the pandemic and during the pandemic, doubled and basically tripled the fees for registration. And for musicians in particular who are dropping a song a week or a track a week, that becomes overly expensive, right? It becomes terribly expensive to pay for. They also made it more difficult to register group works. You can register up to 10 unpublished works, and you can register, a certain amount of published works. But basically, if you're registering one work, or so if you're a producer of a film and you have a film, great. That's an easy thing to do. Or if you are doing one painting a year, that's great. But if you have a bunch, if you're pumping out content all the time, then, you just have to perform a cost benefit analysis as to whether or not you register your works. And again, as an attorney, I'm telling you that it is always best to register your works. But I'm also telling you that you have copyright protection. You are protected whether or not you register them. The advantages of a registration are that is that, first of all, if you want to ever pursue statutory damages, which I can get into outside of this presentation, then you can only do that if you register your works. And, you have to file a lawsuit in federal court. So you can't go to federal court in theory if you do not register your works. You have to go to state court, but most people don't go to court. So there's that. If you do, federal court tends to be better than state court, but so you just have to perform that cost benefit analysis. The reason why I get into that is because I represent a lot of musicians and a lot of producers who are dropping one track a week. And because of that, that's $65 pop, right? And so if you're doing that and you have the money, that's great. But if not, then you need to know that you have recourse regardless of registration. If you do want to register your works, you can register them online at the Copyright Office. It's relatively simple, painless, easy to do. So you just have to perform that cost benefit analysis, right? Now, copyright infringement happens when someone violates your rights. One of those, a bundle of rights: the right to reproduce, distribute, publicly perform, prepare derivative works, and to display. So if someone, if another party violates your rights in any way, and you can establish that you own the work and that they actually copied your work, then you can establish copyright infringement. And your recourse is either, hopefully you don't have to file a lawsuit, but if you do, then it's under the United States Copyright Act, and it's copyright infringement, and that is your recourse. That is how you enforce your rights. So, and that's in and of itself a whole discussion. So if you want to talk about that, we can do that outside of this. Fair use is the last thing I'm going to cover, and I'm going to do this relatively quickly because fair use is basically an affirmative defense to copyright infringement. So there's a presumption that someone has committed copyright infringement, and those who are employing the fair use doctrine are doing that as a defense, right? So a fair use, as I like to think of it, like the classic fair use is someone using a work of like a photograph in an editorial. So if a newspaper, let's just take Andy Warhol, wants to take a painting, an Andy Warhol painting, since his works have been in the news relatively recently, and the Supreme Court has heard a couple of cases regarding that, some of his content. Then, if the New York Times uses one of Andy Warhol's paintings to write an article about a recent Supreme Court ruling, that is editorial, that's transformative. That is what I consider to be like classic fair use. But what you need to know is that fair use is a 4-part test. Okay, so if you are using someone else's work and you think it might be a fair use, it has to meet these standards. The purpose and the character use needs to be educational or like a nonprofit use, not a nonprofit, but not a nonprofit entity, but the type of use, or like an editorial use, something that's transformational. If the purpose and character of the use is commercial, that is going to weigh heavily against you. The nature of the work, it just means that the work is creative, right? So I don't know why this is part of the fair use test, but it is. So we'll just skip right over that. The amount and substantiality of the portion that you use. So if you use a lot of someone's work, that's going to weigh against you. But the last part of the test is the effect of the use upon the potential market, or the value of the copyrighted work. So this is a really important factor. And if your use of someone else's work affects the potential market in any way, then that's going to weigh heavily against you. So the 4-part test, to reiterate, in determining whether or not there's a fair use, and you have to weigh all these factors, is you have to look at the purpose and character of the use, the nature of the use, the amount used, and the effect of the use on the potential market. And the first and the fourth factors are the 2 most important. So I'm running out of time. These are just some slides that go into greater detail on, and elaborate on the definitions, interpretations of the 4-part test, and you will be provided with these slides when this workshop concludes. And so I'm going to skip down to the Andy Warhol case, because I promised Meredith, whose time I'm sliding into right now, that I would review this, and I'm going to tee her up because she's going to start with this, I believe, to talk to you about copyright and artificial intelligence, which I can't wait to hear about because I know nothing about it.
And Ashley, sorry to interrupt your presentation. There was a question, and I think it's going to dovetail into mine.
Okay.
Go through Andy Warhol, this matter, but also there was a question about if you wouldn't mind fleshing out what a derivative work is a little bit more.
Absolutely. Absolutely. I will do
that. They'll need that basis for when I talk about AI. So
okay.
in whatever order you want to do this.
Okay, well, let's get into the Andy Warhol case first. So what happened in the Andy Warhol case, so you can, in this recent case, is, so you can see that there's an image of Prince, and then all of these, what I would consider to be a derivative work, frankly, I think the Supreme Court got wrong, but of Prince. So this is a photograph that's subject to copyright protection, and these are two-dimensional works of art, renderings that were used based on this photograph. And what happened was the Andy Warhol Foundation, they controlled Andy Warhol's works, probably, obviously. And the person who brought lawsuit was the photographer who took this photograph years and years ago. What happened is she had licensed the photographs to Vanity Fair for like a single use, and years and years later, Vanity Fair and some of its subsidiaries ended up using they ended up using that photo, and they ended up using a montage of works based on that photo in following Prince's death in 2016. Okay. And so the issue was whether or not these works right here are a fair use, right? Whether or not they meet that 4-part test. And in the district court, what the court said was that they granted in favor of Andy Warhol, saying that that Warhol's use was a fair use. And then the Second Circuit, the appeals court, issued a slightly revised opinion in 2021. And for the issue before the Supreme Court was whether that commercial licensing of an image that's derived from a photo, the derivative work, for use in publication about the subject of a photograph is a use with a purpose and character different from the original photograph. Okay. And so they focused exclusively on that first factor, which was the purpose and character of the use. And what the Supreme Court said was that the factor didn't favor fair use because the specific use, which was a commercial licensing to Condé Nast, was not for a further purpose or a different purpose than the photographer's photograph. Okay. That in addition to in the addition of the new expression, meaning, or message, were the transformative use would swallow the copyright owner's exclusive right to prepare derivative works. And I'll get into derivative works again in just a second. And I agree with that, that the court that the court ruled against the Andy Warhol Foundation and in favor of the photographer, and said that where the original work and secondary use share the same or highly similar purposes, and the use is commercial, then that first factor, the purpose and character of use, the purpose of the use, disfavors fair use because it's commercial, right? And that makes sense. And there's a lot of legal, flowery language there, but basically if your use is commercial and you're making money off of it, then you've got a lot to prove otherwise if you are seeking to use fair use as a defense, right? Because any commercial use is going to, if it's clearly a commercial use, then you're going to have a hard time establishing it's a fair use. And so going back to a derivative work, I mean, this is a good example of a derivative work, right? So you've got this photograph, which is subject to copyright protection. And then you have another kind of visual artwork that incorporates this photograph, right? And so that's a use, that's a work of art that incorporates another work of art. So this artwork here incorporates this one. This is a derivative, this to the right is a derivative work of the image to the left because it incorporates the image to the left. And the image to the left is a work of authorship that is subject to existing copyright protection because it's not in the public domain. So most photographs are not going to be in the public domain, although there are some that are in the public domain because we're aging, right? And the public domain is no longer 1923. So every year that passes, the public domain is going to tack on another year. So next year, the public domain will be anything, published before 1929. And that will happen January 1st, 2025, right? So for years and years and years, there were a lot of works that were automatically presumed to be in the public domain just because there was no technology to create these works, in the years before the public domain, marker. So that's changing now. And because of that, there's going to be a lot more artwork available and a lot more content available for those of you who want to who want to create derivative works based on other works. And the Walt Disney Company is flipping out over it. Because most of their characters are going to be up for grabs in one way or the other, and they're going to have to, come up with different ways to protect their content. But so the point of that is that, you can have a derivative work where you incorporate another person's work of art. Okay. If that work of art is in the public domain, then you do not have to get permission. If the work of art is not in the public domain, then you need to get permission to use it, unless it's a fair use. And nobody ever really knows whether or not a use is fair. Like, there's a lot of debate about fair use. And there's a lot of professors that get paid to write about fair use because nobody knows the answer. So, when people come to me with questions about whether something is the fair use or not, I generally go, well, I can tell you what I think, and the person down the street, who's equally experienced might tell you something different, and the person on the next block might tell you something different too. So you never want to be in a situation where you're relying exclusively on fair use as a defense, but it is there for you, for those of you who do a lot of sampling and a lot of collaborating, et cetera, et cetera. There's a lot of examples of artists who employ a lot of fair use and need the fair use doctrine and should need it. And there's a reason why it exists, right? It's a doctrine that's subject to a lot of interpretation. So Meredith, did I handle that? Sorry, I'm sorry, I'm stumbling, y'all. I'm just trying to get through all the content a little too quickly.
Perfect.
Okay, great. So I hope I teed you up, and I will exit out of here so
Okay.
that Meredith can share with you. And I appreciate your patience with me. Thank you.
That was awesome. That was excellent. Thank you so much. Can everybody see my slides, my PowerPoint? Do I get a thumbs up or thumbs down? All right, good. All right. So thank you again. I am Meredith Reagans. I'm with Georgia Lawyers for the Arts. We are a nonprofit in Atlanta that provides pro bono legal services to our state's artists, arts organizations, and inventors. So if you live in Georgia, we can help you out. And definitely happy to have more conversation about that. All right, so let's just go over very high level. I think we all know what artificial intelligence is. It's basically a field of computer science that uses technology to perform tasks that require our brain, that our brain otherwise would do. There's a specific area called generative AI that refers to services comprised of algorithms that that the uses can interact with to create content. And that's what we're going to be talking about this afternoon. That these are more what we think of as creative works for artists. A hallmark of these generative AI models is that the term is training with huge data sets, and this can be millions, if not billions of images. And so the whole issue, and then, so the training is the AI platform, they call it, it's called scrapes the internet or scrapes whatever the data source is. And then they come up with, and this is used, like a user like me would enter prompts, and then an image is created. It can be, and we'll go into this in a moment, it can be an image, it can be music, it can be text. So those are sort of the creative works that we're going to be talking about this afternoon. There has been AI for well over a decade, if not decades. And this is in sort of the, this is in speech recognition, customer service, image or computer recognition, supply chain, forecasting the weather, detecting anomalies in data. So corporations, companies, research and development, they've been using this for, like I said, well over a decade, if not decades. So there is, I mean, and as we know, AI is ubiquitous now in our society. It's everywhere. It's on our phones. We use it when we do a Google search. That's a part of AI. So there's a great aspect of AI. And I say, it is a double-edged sword, especially as it relates to creative works. It actually can assist you as artists across a lot of different disciplines. And so artists use this to create art. And then if you're somebody like me who has absolutely zero artistic ability, I actually am able to create art, which is pretty fantastic. But there's the downside of this, and it's that this underlying information, this underlying data that creates these works, they are most likely, and we don't even know what they all are. That's the problem, is we don't know what the millions or billions of underlying data is, but those are protected by copyright law. There's some form of protection. It's just, there's so much information that's being scraped. We don't even know how to find it and identify that that's the source. So what role can AI play in art? And this is going back to the positive. It helps you create. You can create general art, original art, music, literature by learning from existing works. You can enhance existing art, such as upscaling images or colorizing photographs, but it also allows you to collaborate. Some of y'all may have used some of these platforms like DeepArt or DALL-E, which create unique visuals. I'm going to show y'all, and I'm just going to go through this really quickly. This is my art, quote unquote art, that I created, and I'll put that in quotes too. This was the prompt: an old man sitting on a beach drinking a beer. And you can see this came up in like 1 second. And you can see it's a photographic image. For some reason, the beer bottle is levitating. But I had, this is somebody took this photograph, or maybe the image of the man is sitting in a chair was the image, and then they put the beach and then obviously the beer. So there are so many different elements. And like I said, to figure out how this is created is a bit of a mess. This is the neopunk. So you can put what type of images or style you want. This is the neopunk image using the same prompt. And here's the comic book image. As I said, you can also create music. There are, the platforms are Amper Music, artificial intelligence visual artists. And I actually did this. I'm not going to play it for you because it's actually super scary. But I was able to create, again, music And this was the text, the prompt, the old man on the beach. And then again, there's literature. So this and people are now using this, for all sorts of things. I mean, hopefully, and just like Ashley, I teach, law school, and I teach contract drafting. And so this is our big concern, is our students are now using AI to draft things. But I put in a prompt that was a story about Meghan, an American who marries Harry, a British prince, and they moved to the United States after a falling out with his family. And within 1 second, this pops up, and I said the style is going to be a rap. I'm not going to read this to y'all just because of time, but literally, I could have worked on this for 3 months and it would not have been as good as what AI created for me. To me, I don't have a technology mind. So this is truly mind blowing to me. All right, let's get into the law for a moment. And I'm not going to bury the lead. We really don't know what's happening. We are on the cutting edge. Not only are we on the cutting edge with AI, but the courts, we just really don't have a lot of guidance. The courts aren't really sure. Congress hasn't, surprise, surprise, we have inaction by Congress on this. But I'm going to show y'all a little bit about, at least we have a little bit of understanding. And then, like I said, we'll come back to this in a year or two, and hopefully we're going to know a little bit more. I'm sure this is the case that Ashley knows very well. This is the bottom line of this is that only humans can create creative works that have copyright protection. So this handsome fellow right here is Naratu, and he is a black-crested macaw, and this is such a crazy case. There was a wildlife photographer who went to Indonesia, and he put down his camera, and Naratu took what I think is the best selfie I've ever seen in my life. This macaw this is his photograph of himself. Well, David Slater, the photographer, created a book and sold it with some of the selfies. This wasn't the only one. PETA actually filed a lawsuit on behalf of Naratu alleging copyright infringement against Slater. This went through the courts, and based on the Copyright Act and actually the Constitution too, the Ninth Circuit, which is basically out of California, said that the Copyright Act, which we talked about earlier this morning, only grants rights to humans and not non-humans. So what does that mean? It means no one has it means no one has copyright protection in this image if Naratu, who actually took it, doesn't have copyright protection, and David Slater didn't take it. So all of these images are in the public domain. So what this means going forward is if a non-human can't have copyright protection in a work, machines and so we take that step and say machines and computers and platforms that create works, there's no copyright protection in those works. So that is like the definitive sort of law that we can absolutely hold our hat on. But of course, it's a law, so things get a little murky when we're adding, what if a human adds some level of creativity to this? How does that play out? So, going back to what I did, I'm not going to have, we'll get to that. All right. So, this is kind of an overall, just where the law is. The test for copyright status is whether the works reflect human creative expression or is it merely a product of automated processes? So that's exactly what we were just talking about. But if AI generated elements predominate and lack significant human intervention, so this is one step better that, okay, we know there's been a little bit of human intervention, but AI generated elements predominate, then there's no copyright protection. But what if there's a blend of AI generated and human authored content? In this case, the human authored content may be eligible for copyright protection, okay? And you're going to see some cases, we're going to talk about a few cases where it's a little blurry, but we've seen what the courts are going to do, or it's either going to be the Copyright Office or the courts, depending on if it gets appealed. So this is called Zaria of the Dawn, and you'll see all of these cases are really recent, 2023, 2024, maybe a few out of 2022, but as I said, this is all super cutting edge stuff. So this was a graphic novel written by Christina Kostanova and illustrated entirely using Midjourney, a text-to-picture artificial intelligence platform. So what she did is she wrote the text and she arranged certain things about the text. She put the text into Midjourney, and then Midjourney created the images. All right, I'm going to show you. So you can see the text. It's a little fuzzy coming through, but you can see, like, here's the text, here's the image. All of these images were created by AI. So what the Copyright Office said in 2023 is that with respect to the copyright in the text and the selection and coordination, Kostanova has copyright protection related to that. But the visual elements, like the graphic design that was created by AI and Midjourney, there is no copyright protection for that. So this is one case where we see that there is some protection if there is, if the author can show that he or she actually created this work. All right, here's another work. This is created in part by Jason Allen. So you can see Midjourney created this original image on the left. And then what Jason Allen did is he put in 624 different prompts and refined it. And he actually entered this. And so he spent a lot of time refining this work. I don't speak French, so I'm not going to embarrass myself, but it's Space Opera Theater is how it's pronounced in English. And so you can see certainly the works, you can tell they're very similar. But the secondary work has a lot more detail. So this is what the court said. So he actually entered this into a fine art competition in Colorado and he won. And he did tell people, he did admit that he had used Midjourney, but I don't think the judges really understood what Midjourney was. So he sends the image because he wants to get this registered with the Copyright Office. And he acknowledged, well, he wouldn't disclaim the Midjourney impact on this, or what Midjourney had done, like the nature of the underlying work of Midjourney. And so the Copyright Office, because he refused to disclaim it, citing his input, that this was all his input with the 624 prompts, the Copyright Office did not give him copyright protection and would not allow registration because they said that the work contained more than a de minimis amount of content generated by AI. So this is a case where the underlying image was created by AI. He made a lot of different, he even used Adobe Photoshop with this. He used Gigapixel AI. He put a lot of time into this, but the Copyright Office would not allow this because they said it was more than de minimis. All right, here's another case that happened in December 2023. So this was the original, you can see on the left is the original photo taken by an artist named Sonny. Then he puts that into the AI. I can't remember. Oh, it's called Raghav is the AI painting application. So then he took the photo and he wanted it interpreted in the style, and you can do this. You can use the style of another artist in the style of Vincent van Gogh's Starry Night. And you can see on the right, he called it Suryaст. Suryaст, this was the image, and you can definitely see Starry Night in this. You can see the sun going down over the house. So you can definitely see like the photograph in the image of Starry Night. Well, let's see what did the Copyright Office say? He argued, this is what he argued before I tell you what the Copyright Office said. He argued that because there was human authorship, because he chose the photograph, and he also and it was his photograph, he selected the style, and he also chose the variable in the amount of the style that this was human authorship, that he did all of this. And the Copyright Review Board, this had many, this got appealed several times, determined that the work was a derivative, so there was no fair use. So this wasn't transformed. This was a derivative work that we just talked about. So even though, you know, this was the original work, the Copyright Review Board said this was derivative. And so there's no, well, actually, I'm sorry, my apologies. I don't think this was his original photograph. But that there was, so my apologies about that, but this was a derivative work, and the registration again is refused for insufficient human authorship. So this is another work that Mr. Thaler created, Stephen Thaler. What's interesting about this is not only did he create the work, he created the software, he created the AI program that created the work. And so he created this creativity machine. The Copyright Office denied registration and said it lacked the human authorship necessary to support a copyright claim. So you're seeing, this is what we just looked at was kind of the output, the secondary use that was created. And we're not seeing, unless that you can show, which Castanova was able to, that you were the one who really had some creativity in this. The Copyright Office and the courts are not allowing these secondary uses to get copyright protection. The Copyright Office, a little less than a month ago, so not quite 2 months, I mean, a little more than a month ago, they actually issued a report. But it's just part one. So we're waiting for the copyright to let us know, like, please give us some guidance. We need to know, you know, how are, you know, the courts and you know, people who are using technology, we all really need to know this. So the first part that was released on July 31st only dealt with digital replicas or deep fakes. I think we've all seen deep fakes. And what that is how AI is realistically but falsely portray people in digital media. So essentially what the Copyright Office has said is, Congress, please pass legislation to protect digital copies of voice, image, and likeness. I'm not going to go into what their recommendations for the statute would be. I don't even know how hopeful we can be that we're going to get some action. I mean, the one good thing about this, and Ashley may know this better than I do, this is pretty, I mean, I don't think of this as a partisan issue. I feel like people on both sides of the aisle have different takes on this, and it doesn't break down in Republican versus Democrat. So that actually gives me some hope that these guys can get together. But I also think this gets so complicated. But I know the Copyright Office, and I've spoken to people in that office, they really are trying to get Congress to act, and they're lobbying Congress to do something. Interestingly, so I'm just going to give y'all a really quick international example. This is a case out of Beijing, and this was totally created by an AI tool. And interestingly, the Beijing Internet Court found that this was an original work, because it did not exist before the human creator created this from stable diffusion. So this is 180 degrees different from what our courts would say about this. If this were in the US, there would be absolutely no, this wouldn't be found to be an original work, because the author was not a human. Very quickly, the EU has actually acted as of August 1st, 2024. So again, within the past 2 months, there's a law that's come out that's going to govern the EU on AI. They classify it in terms of risk of harm to essentially the original copyright owner, that original the original work, the original owner. I'm not going to go into this, but just know they are a bit ahead of us, and maybe by the time, I mean, who knows how long this is going to be. This is coming into effect over the next 6 to 18 months. Here's some current cases that we just don't know how these are going to play out. This is Getty Images versus Stability AI, and this was the Stability AI was the platform that was used in the case from Beijing. What is so crazy about this is you can see the Getty image. So the original Getty image is these guys playing soccer in London. You see the Getty Images watermark. Well, this is the image that was created by Stability AI. Literally, the Getty image watermark is on here. So if there ever were a case where you could go back and say this was an image created by a copyrighted work, or on the, that was taken from a copyrighted work, they got this. I mean, Getty, and any of you who are photographers know Getty Images, they are very protective of their works. So Getty brings a lawsuit in 2023 in Delaware, and they allege that Stability AI copied 12 million images, many of which were Getty images and titles in their captions. And then what Getty is alleging is that what Stability AI is doing is they're now used to compete against Getty Images. Okay. And I don't know if we have any lawyers on here, but they are still briefing motions to dismiss, and it's been 18 months. So bottom line is this case is going nowhere. This is going to take years to resolve. I mean, Getty Images has them dead to rights, because they took the image, a copyrighted image, in this one case, but I don't know how this is going to play out. There's another matter that, believe it or not, was set for trial about 3 weeks ago, or maybe now close to a month ago. I haven't seen if the trial actually started. This is not really this isn't an artist case, but it's about text. There is a company called Thomson Reuters, and they have a legal platform called Westlaw that has all of the cases. It's a platform where lawyers can digitally read cases, and they allege that Paxton took some of their information and created basically a competing business that competes against Westlaw. The defendant, and we talked about what fair use is, that it's a defense to copyright infringement. So basically Ross is saying, yeah, we didn't pay for your underlying, your text. We know you have a copyright protection to that, but it's fair use. And the court said this needs to go to trial. And like I said, the trial was supposed to start a month ago. I have not seen that it started. And I've looked diligently, but I can't find that it actually started. But this is going to be an important case, and for people in the legal community are going to look at this. Let's see. All right, I'm gonna there's a case from New York Times where Microsoft and OpenAI took some of its text, and I don't know if y'all can see this, but they pretty much just stole the text. And when what Microsoft did was they put this was in one of their platform. And so you can just see it's almost exactly like there was little to no transformation at all. So we talked about, I'm gonna go straight to Warhol. Ashley did a great job talking about this. This was actually the original article in the Vanity Fair. So this image, and I'll give you one more little background. Lynn Goldsmith took this image in 1984 when Prince was just coming on the scene. And then when Purple Rain hit, they licensed the image. Our Condé Nast, or Vanity Fair actually, licensed the image, and she showed you, these are the photographer had no idea that Warhol had created all of these images until Prince died. And so then we talked about all this. So the most important thing, and this is what we actually hit this, and we see it exactly the same way. What Sotomayor, and it's interesting, especially for people who follow the court, Sotomayor and Kagan are always thought of as like always being on the same side, but they kind of like hit it, busted heads on this one, because Sotomayor said, this is the exact same use. And Kagan said, well, but this is a new expression. And so we should be more on the side of the creator, or on the secondary use, that was transformed, and that it was a new expression, meaning, or message. But again, what the majority, it was a 7-2 decision, said is we have to look at the use, and it's exactly the same. So what does that mean in the AI world? So before Warhol, the courts are finding the creation of generative AI platform using unlicensed trained data. They were saying it was fair use. Arguably, the use of content to train a platform that generates content is precisely the kind of highly creative or innovative use that the courts have found transformative. So I didn't go into the Google case, but basically the courts in sort of the technology world were finding that there was fair use. And like I said, I kind of blew through that. But before Warhol, we were seeing that it was that there was fair use, and that so the secondary user of the underlying work did not have to pay. It was allowed to use the work. But what Warhol does is it complicates this analysis. In Warhol, the court, applying just that first fair use factor, held that the purpose and character of Warhol's orange prints was similar to Goldsmith's, the photographer, as both works were licensed for use in magazines. So what does this mean for the future? Does this mean that a plaintiff artist can defeat a generative AI platform's fair use by licensing his or her work to similar generative AI platforms? So what I'm saying here is, what if the underlying artist licensed work, or the original artist's work, he or she licenses it to a similar AI platform, and then the artist can say, listen, there's no fair use because we're using it in the exact same way. Or by pointing to other artists who have licensed their work to generative AI platforms. So again, I know I went through this super fast, but we just don't know. The Andy Warhol case came out, that was decided in May of last year, so May of 2023. These cases, I haven't even seen any cases yet on this, like how the courts are even interpreting these, and Ashley may have, but we just don't know. My guidance to you is, be careful if you're creating works using generative AI. Because I just don't think there's going to be protection. As far as your work's being used by generative AI platforms, it's happening. I don't know how the courts are gonna figure this out. I don't know how Congress is gonna figure it out. There are not many cases like that Getty Images where we can really, we can see, oh, this is real, this came from this image. So I wish I could give y'all more guidance, but I would just say be careful. Thanks, y'all.
Wow. Thank you, Ashley and Meredith. That was a wealth of information. I do want to be respectful of everyone's time, and we were supposed to end at 12:30, but we have 7 questions in the Q&A. Ashley and Meredith, if you'd like to answer them live, you can. If not, I can send them to you via email. And when we send out the materials, you can place the answers there. So it's up to you. And if anybody has to leave, again, the recording you will receive it via email, and it will also be housed on South Arts website under professional development.
Right. And there was one question that I did answer in the chat. I'm not seeing any others that I didn't, but if I'm missing something, please let me know, and I'm happy to respond anyway.
Well, yeah, we have them in the Q&A section as well. Yeah. So let's
Okay.
see. The first one says,
There we go. There we go.
would the
Okay.
work for hire doctrine apply if someone volunteered their time but signed an agreement relinquishing their rights?
Okay. So if you want, I'll go through this.
If you have time, yeah,
Oh,
absolutely.
absolutely. Absolutely.
Okay.
So and I'll just read what I wrote in the chat, because that way I don't go off
Okay.
and talk too much like I have been. The work for hire doctrine applies regardless of whether you're getting paid in the scope of your employment. However, if you're not employed, and I mean, that's a term of art, right? Then you own any copyright until you transfer it. So for example, that scope of employment test does not apply to independent contractors. So if you're an independent contractor, the only way that if let's say that you're being commissioned to deliver a work of art, or what have you, then if you're an independent contractor, it needs to be in writing, in order for you to transfer your rights. And so the scope of employment, that scope of employment does not apply to independent contractors because you're not employed. So they kind of use the W-2 definition of employment.
Okay. Thank you. The next question, excuse me. A musical artist verbally asked a visual artist to create an album cover with no signed contract. The visual artist was paid a flat fee and received credit for producing the artwork for the album. 30 years later, the artwork is reproduced on apparel and other products for other companies without consent from the visual artist. What are the rights of the visual artist in this case?
Do you want me to take a stab at this?
Yeah.
So it depends. So if there is, the fact that there's no written contract, I mean, that doesn't mean that there's no recourse, because verbal contracts are enforceable too. And anymore, I mean, it's 30 years ago, so you're not going to have this, right? But we document everything anymore. We're contracting all day, every day, whether or not we realize it, which is kind of terrifying, just by texting and emailing, right? As long as there's some consideration. But to answer this specific question, if there is some sort of evidence of any limitation in the license for the use of the artwork on the album, then the visual artist has recourse. If there's no documentation, it's going to be tricky, because assuming that, there is documentation of the payment, right? Then, and of the license, then it's just going to be a matter of he said, she said, right? If there was an agreement and the visual artist licensed their work to the for the album artwork, again, I mean, the difference in having viable recourse for the use of the same image and merchandise 30 years later is going to be the ability to point to some sort of limitation in the documentation. And that's, I mean, if you didn't authorize it, then you have to show that you didn't authorize it. It'll be tricky.
All right. In the early days of Facebook, I posted a photo that I took of a person that I wrote a story about. It was stolen by someone who posted continually on a public page on Facebook. Is there anything I can do to stop this or give me credit for the photo?
Absolutely. I mean, if someone steals your photo and it's your photo and they're using it without your permission, then you just require them to stop. You send a cease and desist letter.
All right.
Would you
Is
agree,
it
Meredith?
I'm sorry.
Absolutely.
I don't mean to just butt in. Sorry.
Okay. Is it permissible to mention a song's title and or its recording artist's name in fiction writing, not including any lyrics?
As long as you're not using it for commercial purposes, I mean, I would want to talk more about that, but if you're just referring to something, then it depends on the context. It depends on the context. Generally speaking, yes. I mean, you have First Amendment rights, but it depends on the context. I hate to just give you a general answer. I would have to know more.
I'm wondering about when you have gotten permission to use a piece of music and post an original video to YouTube and it is flagged for copyright infringement. How do you tell YouTube that you have permission?
You just you provide them with documentation.
Okay. And
So-
our last question says, Ashley, I'm currently working on a book project related to a private art collection. The book is under contract with a nonprofit university press. Would we need to get permission to include images of the collection from the owner of the private collection or from each of the artists whose works are in the collection?
So the owner of the private collection should know whether or not they have the right to contract with you. And if they don't, then you'll have to get all of the rights from the individual artists. But hopefully the owner of the collection worked that out, but that's not always the case, right? Because the owner of the collection may have what we call naked ownership, may be able to use the rights, for their own purposes, but may not have the copyright. It just depends. I hate to say it just depends again, but it depends.
Okay, and one last question came in, and this is the absolutely last question. Can an organization polish its copyrighted logo without interrupting its protection?
You mean publish?
Yeah, I think that's what.
It said polish, but I'm going to assume publish, or I don't know if they meant alter or make changes.
Yeah, that's Meredith, you want to take that one?
The
Okay.
latter, polish it. Obviously we use it for printing, but it's just kind of old and a little bit out of date, and we're wondering how much can we update it without damaging the copyright?
Oh, okay, so assuming that it is copyrightable and that the logo is.
It has already been copyrighted.
Okay, well then you have the exclusive right to prepare derivative works of your own work.
Okay, thank you.
You're welcome.
Well, again, thank you, Ashley and Meredith. Thank you all for attending. And you should receive these, I'm going to say by early to mid next week. So give us a little time to get everything prepared. And please, look out for more professional development opportunities from South Arts, and everyone enjoy the rest of your afternoons.
Thanks, everybody. Thank y'all.
All right, bye-bye.
Thank you.